People often talk about the power of touch, of how one simple touch can have a tremendous impact on another person. In United States v. Jones, we learned that a simple touch, when combined with the intent to gather information, has the power to trigger the protection of the Fourth Amendment. In 2004, Antoine Jones was the owner and operator of a nightclub in the District of Columbia. He was also a large-scale trafficker of cocaine and the target of an FBI investigation. As part of their investigation, the FBI wanted to place a GPS tracking device on Jones's Jeep Cherokee. That decision to put a GPS tracker on a car changed the way we understand the Fourth Amendment. The FBI believed that by tracking Jones's movements, they would gather information about where he obtained his cocaine, where he stored his cocaine, and who he sold his cocaine to. The FBI applied for a tracking warrant to install and monitor a tracking device on Jones's Jeep, and a magistrate judge in the District of Columbia issued the warrant. Now, there are two requirements that officers must follow when executing a tracking warrant. First, the officer has 10 days to install the warrant. Second, the tracking device has to be installed in the district where the warrant was issued. Since a D.C. judge issued the tracking warrant, the device was required to be installed on the Jeep when it was in the District of Columbia. Well, as luck would have it, law enforcement did two things wrong. They installed the tracking device 11 days after receiving it, just 1 day late. And they installed the tracking device in Maryland, not D.C. So the warrant was not lawfully executed. But back then, our understanding of the Fourth Amendment suggested that the tracking of the car would still be okay. Most believed that a Fourth Amendment search was defined exclusively by the Katz case. Under Katz, a Fourth Amendment search occurs only when there is an intrusion into an area where there was a reasonable expectation of privacy. Since Jones was driving his Jeep on public roads, he could have no privacy in the tracking of his car in public, or so we thought. The FBI did use the GPS device to track the movement of Jones's car for 28 days. That information connected Jones to a stash house where agents found 97 kilograms of cocaine and over $850,000 in drug money. Jones was indicted and later convicted for conspiracy to distribute cocaine and other charges. Jones appealed, arguing that the evidence of where he went for those 28 days should not have been admitted at trial. His appeal was eventually decided by the United States Supreme Court. The issue before the Supreme Court was whether the placing of the tracking device on Jones's Jeep and the tracking of his car for 28 days violated the Fourth Amendment. The government conceded that they could not justify the tracking based on the D.C. tracking warrant, since the officers put the tracking device on the Jeep in Maryland, not the District of Columbia. But the government argued that the police did not need a warrant to track a car that was traveling on the public roads. Applying Katz, a person should not have an expectation of privacy when they are traveling on an open public road, where anyone can observe them. The Katz decision suggested that it is not a Fourth Amendment search if someone is doing something in public without an expectation of privacy. Other Supreme Court cases made it clear that there is no reasonable expectation of privacy in the outside of a car. The Supreme Court rejected the government's argument and suppressed the evidence gathered from the GPS tracking device. In the majority opinion, the Supreme Court did not focus on whether Jones had an expectation of privacy in his public driving. Instead, the court focused on the placing of the GPS tracker on Jones's car. Justice Scalia, looking back at cases that were 80 years old, cited a second definition of search under the Fourth Amendment. Avoiding the issue of privacy, Justice Scalia simply referred back to the language of the Fourth Amendment, which says that people have a right to be secure in their persons, houses, papers, and effects. The court noted that Jones's Jeep was his effect under the Fourth Amendment, and he had a right to be secure in that effect against government intrusion. The court then looked at the government's actions. The FBI physically touched Jones's effect when they placed the tracking device on the Jeep, and they touched it to gather information. That is, to learn where Jones and his Jeep were going for 28 days. The majority of the court found that this was a search under the Fourth Amendment. Since it was a search, law enforcement needed a search warrant, or a judicially recognized exception to the warrant requirement, in order to place the tracking device on the car. In Jones, the Supreme Court reinvigorated an old definition of search. And now law enforcement must realize there are two separate ways to trigger the Fourth Amendment. First, it is still a search when law enforcement intrudes into an area where a person has a reasonable expectation of privacy, as outlined in the Katz case. Second, it is also a search anytime the government touches or physically trespasses on a person, house, paper, or effect with the intent to gather information. Law enforcement touched Jones's car to gather information about where the car would go. That is a search which triggers Fourth Amendment protections. There were two concurring opinions in Jones, which will also have an impact on the definition of a search for years to come. But that is a talk for another day. For today, it is important to understand that there are two definitions of search. In United States versus Jones, the court held that it is a Fourth Amendment search anytime the government touches a person, house, paper, or effect in order to gather information. A touch by law enforcement combined with the intent to gather information has the power to trigger the Fourth Amendment. My name is Mike Bunker, and this has been a FLETC Talk.